Hello. Just a quick pop-in with an update on Lori Vallow Daybell, who was scheduled for jury selection today, May 29, 2005. However, recently she had filed a motion to recuse or actually remove Judge Beresky from the case, citing that he was biased against her based on motions and comments and things just not going her way in the last trial. Well, Maricopa County, to its praise, has brought it before Judge Jennifer Greene. Let's pop in and see the results.
Good morning, everyone. The court calls CR 2022-00124201. This is State versus Lori Daybell. Appearances, please.
Treena Kay on behalf of the state, and for the record, the victim is appearing virtually.
Thank you.
Lori Vallow for the defense.
Pamela Hicks, advisory counsel.
Thank you. There was this got set very quickly. There was a media request that I became aware of in passing, literally on my way over here. I don't have a written request. I have not read all my email because I've been on the bench this morning. Do you want to make a record with regards to the media request from the state?
No, Your Honor.
Okay, from the defense?
No.
Okay. I don't see anyone here. I thought we would address it on the record, but I don't see anyone present from the media. Okay, I assume there's no objection if they come in. Ms. Kay?
No, Your Honor.
Ms. Daybell?
I always object to them, yes.
Oh, you object to them?
Always.
Okay. Is there anything you wanted to put on the record?
No.
All right. My thought is if they come in, we can address it. All right. The court's, this is the oral argument on Ms. Daybell's motion for change of judge for cause. The court's in receipt of and has reviewed motion to disqualify judge. This was filed on May 20th, and the state's response to defendant's motion to disqualify judge. Ms. Daybell, I've read your motion. In summary, the way I read it, you're asking for the court to remove Judge Beresky for cause under Rule 10.1. You cite several reasons, specifically that he's denied various motions. You mentioned facial expressions. You mentioned a belt and his not allowing you to remove it. You assert that he violated your speedy trial. There's a mention of religious persecution and an allegation of personal bias. So you're going to get, and then the state's response is that simply that the defendant does not establish judicial bias, appearance of bias, or fundamental error. Of course, under Rule 10.1, the court is evaluating whether or not Judge Beresky can be fair and impartial and whether he can conduct a fair and impartial trial in this matter. So I'm aware of the allegations. You'll have the opportunity to go first, then I'll allow the state and to address the court, and then you'll have the last word. Whenever you're ready, Ms. Daybell.
Okay. I did file this motion.
No, I'm sorry. Can you pull the microphone? I'm sorry.
Sorry. I did file this motion and this affidavit after several attempts to, I made an oral motion with Judge Beresky and asked him to recuse himself because of the bias and prejudice that I had seen during our last trial and throughout the whole entire time that he has been the judge over all of these cases. And he refused to do so. So I thought I needed to put it in writing and put all my points in that I felt like were causing him to be biased and prejudiced against me, and that obviously you've read it, so you've seen all the different things that I put. There was an actual comment during trial when I was cross-examining one of the witnesses where he said to me directly after an objection from this state that I was comparing myself to biblical prophets, which I absolutely was not doing. And I didn't even realize it until someone showed it to me on the FTR afterwards that he had even said that, because I was in the middle of questioning the witness. And so there's several times that he made comments directly to me. I tried to address this with him directly in our last hearing on May 14th, where I asked him why he had denied every single motion that I had ever filed in the last year and a half. And he said that my motions had no merit. I asked him if my prior defense team, that he denied all of their motions. that they had no merit as well. And then I asked him, my prior defense team before that, all the motions they filed were denied, and did they have no merit at all either? And I asked him again if he would recuse himself from this case so that I could get a judge that was impartial and fair and have a fair trial. That is my right, my 6th Amendment right and my 14th Amendment right to have a fair trial, an impartial trial, and not a judge who has some kind of bias against me.
All right, anything else? Thank you.
Judge, just the prior defense motions almost all exclusively dealt with motions to preclude the media. Judge Beresky applied the appropriate law in finding that the media had a right to be present and tried to limit it by saying things like they couldn't focus on the defendant's papers or things like that to mitigate any of the concerns by the defendant. All of the defendant's motions that she has filed have been without legal basis. They've been appropriately ruled on, and the state's motions that the state has won have been ruled on based upon, again, legal basis. So the fact, as the court is well aware, that the defendant has had all of the motions ruled against has no basis for bias if they're all been ruled on based upon the rules of law and the rules of evidence. So we see nothing that the defendant has provided here that would rise to a level to preclude or recuse Judge Beresky from this case.
Thank you. Ms. Daybell, you can have the last word.
Yes, also, along those lines, Your Honor, that's one thing that I asked Judge Beresky is that he has denied all these motions with no finding of fact and no conclusion of law. I said, what is the finding of fact and conclusion of law? These are just denied, 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 denied. He's also denied several attempts for me to try to ask the state for discovery that he's just denied outright. And then as I keep filing more and more, as I find out what we don't have and I ask for it, I'm continually, even to last week, getting brand new discovery with brand new Bates numbers, stuff that they realized they never even had before that hadn't been turned over. And I've been asking Judge Beresky for these items for 1.5 years. And I'm getting them 1 week before trial. We start picking our jury today. We're supposed to be doing our strikes today. And along those lines, I had this motion about the RAC belt that I had asked him about since we went through this whole trial, and there was times when the belt didn't fit around me, so it fell out of my clothing. We had to stop trial and I had to go fix it. And that is what MCSO recommended, that if that was too burdensome, that they would put an armed guard in the back. And because of the media that Judge Beresky has let into every single one of the hearings and the trial, that they already have an armed guard back there. So it wasn't going to cost the state any more money. It wasn't going to cost anything if he just had them remove the belt and went over the security that the MCSO actually recommended. Every single thing that I asked for has been denied. I feel like he does have a personal bias against me, and all I'm asking for, I went through a whole trial with him, even thinking he was biased against me before the trial started. I filed for a new motion because it came to our attention through the media. The media sent Judge Beresky a clip of one of the jurors saying that he found out about my prior convictions beforehand, before his deliberations. And this is the same exact juror who was brought in twice during trial by Judge Beresky, where he had to admonish him for, 1, being on his phone, and 2, talking to one of the other jurors about the case. And now he's saying, well, he went on another media thing and said that he took it back. He took back what he said. So I'm not going to give you a new trial, and nothing was done about it. He refused to call them in and have a hearing and put him on the stand under oath and ask him if he found out this information prior to deliberations. It was very confusing, and everything is just outright denied. I want to go to trial. I want to have a fair trial, as fair as possible. I don't feel like I can do that with Judge Beresky, and I would like to be appointed a new judge who wouldn't know anything about the case and be fair and as impartial as possible. Thank you.
Thank you. I've considered the written motion and the response, and certainly your comments today from both sides. Ms. Daybell, I find that The fact that you disagree with Judge Beresky's substantive legal rulings is not a valid basis under Rule 10.1 to grant your motion and give you a new judge. The standard in 10.1 is, has he demonstrated he can't be fair and impartial? And the fact that his rulings have not gone your way is not a valid basis to suggest that he can't be fair and impartial. Unless there's some other allegation of bias that's been demonstrated, I don't find on this record that it has been demonstrated. I certainly understand your frustration with the way that the rulings have come out, and it sounds like the way that they came out with prior counsel, but the things that you have cycled through at length in your motion to disqualify, I've considered all of them. Whether or not he should have ruled differently, for example, the example you gave with the juror, or with making findings of fact and conclusions of law in writing, some of the issues you have, if you have concerns about his substantive legal rulings, you can file a motion to reconsider, or you can take them up on appeal. You can file a special action. You have a number of legal remedies at your disposal where you can make those arguments, but they're not grounds under Rule 10.1 to get a new judge. So I am going to deny your motion. Again, as for your concern about his substantive legal rulings, you can address those concerns in a different way, but it would not be under a 10.1. And on this record, I don't find that he's demonstrated that he can't be fair and that he can't be impartial. I also wanted to address the comment that he made that you illustrated. That comment alone doesn't demonstrate that he can't be fair and impartial. I'm not exactly sure of the context where he made it, but it sounds like he let you ask a question with regards to religion, and that was his decision. But again, I don't think even that demonstrates that he can't be fair or impartial in this case. All right, so I'm denying the request to disqualify Judge Beresky under Rule 10.1. Is there anything else from the state?
No, Your Honor.
Anything else, Ms. Daybell?
Nope.
Thank you, we are adjourned.
Okay, well, there we have it. Judge Jennifer Greene has decided that Judge Beresky can stay on the case. I'm sure Lori Daybell is not very pleased with that. But as Judge Greene said, none of it really matches up to legal merit. We watched the trial, and Judge Beresky did everything he could, especially in the pre-trial hearings, to give Lori Vallow Daybell the best chance at getting a fair trial. He offered continuances, he double-checked, he went right up to the bar of, before giving actual legal advice. He double-checked. He really was patient as far as I was concerned, while getting attacked constantly. It's going to be quite the trial, but it looks like it's going forward. Now, immediately after Judge Greene's determination, they went forward into Judge Beresky's courtroom to start jury deliberations. And from what I understand, that went pretty quickly because they did the electronic questionnaire and it was all filled out before, and they were able to eliminate a lot of people. As far as I can tell at this point, they have at least 60, maybe more, candidates to go forward with tomorrow. To try to do the personal interviews and go forward. Nate Eaton from East Idaho News has been doing a thread on X and also on his website. And I'll link the website below, because Nate Eaton, in regards to Lori Vallow Daybell coverage, has been on it and on it and on it from day one. And he deserves the tag. So thank you, Nate, and thank you for covering the hearings today. On that, I need to tell you that during the jury selection process, there was basically like a mini pretrial hearing to deal with some issues that Lori Vallow wanted to bring up. And, Judge Beresky had already said they would deal with some things tomorrow, but she brought up a very valid question for her, and he wanted to address it right away. Again, always making time for her and trying to educate her on why she might be looking at it or using the wrong references. He's not really disparaging or rude about it. He's educating about it. And he's doing the best he can to give her a fair trial, in my humble opinion. But on that, let's peek into that. You guys can judge for yourself.
understanding that we did over my objection last time.
Well, we actually didn't do an aggravation phase. You
Well, I
Admitted.
stipulated to it,
stipulated to it.
correct. But in adding it to, at the end of trial, a whole guilt phase for aggravators, my understanding is that in January, the state filed their motion, the state's allegation of aggravating circumstances, right? And then my understanding is that that can be brought to the jury during guilt phase. And so, but it hasn't been brought to them yet because it's after the indictment. So it needs to have probable cause hearing, which is the 13.5 hearing. So we need to have a probable cause hearing so that we can add that to the guilt phase. And that's something that gets taken to the jury after probable cause has been found for these aggravators that are alleged.
I think you're referring to the rules for capital cases when there's aggravators filed in death penalty cases.
Correct.
You're entitled to a probable cause hearing, depending on the aggravator. This is not a capital case.
I know it's not a capital case. And in normal capital cases, you don't have an aggravation phase either, right? Only in a capital case.
Actually, you have a guilt phase, and then you have a mitigation aggravation phase.
Actually, have a guilt phase, an aggravation phase, and a penalty phase.
Right.
If the aggravators aren't found as a completely separate independent hearing, then there's no penalty phase.
So with the statute for this charge only being the one statute, what are you getting out of the aggravation phase? I don't understand.
Well, first of all, the jury in the initial phase doesn't determine whether or not it's a dangerous felony, which they need to find. And then the aggravators, I think the state has a right to attempt to prove those to the jury, to offset any mitigation or to be weighed against mitigation at your sentencing.
And isn't that normally put together with the guilt phase? Like they would have that on the back page where it says the aggravators and the guilt?
No.
So are we going to have a whole nother aggravator phase in this case?
If the jury finds you guilty of the charge and the state wants to proceed with aggravators, yes.
And so we do not have to have a hearing to determine if there's probable cause for these aggravators?
No,
They're just alleged aggravators.
correct,
And the grand jury never found probable cause for them.
correct.
So you're saying that if the guilt phase goes through and they find you guilty, then you have an aggravator phase added to that.
That's what I said.
Okay. Hold on one second.
You have the allegation of aggravating.
Okay.
It was on my desk.
Your Honor, I would just like it to be on the record clear that the Rule 13.5 that I'm talking about is about non-capital cases. I know in capital cases, they call it a Cronus hearing, but this is for non-capital case.
Well, it says under 13.5A, a defendant may challenge the legal sufficiency of the state's allegations by filing a motion under Rule 16. Is that what you're talking about?
Correct.
It doesn't say you get a probable cause hearing regarding the aggravators.
Well, I'm challenging the state's allegation of aggravators by asking for a 13.5 hearing on it.
So the state's aggravators that they've alleged is that the offense involved the infliction or threatened infliction of serious physical injury. The offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of the crime, specifically a gun. The offense involved the presence of an accomplice. The offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant, caused emotional or financial harm to the victim's family. The next one is the defendant was previously convicted of a felony within the 10 years immediately preceding the date of the offense. This one's really not very specific. Any other factor that is relevant to the defendant's character or background. So if you were found guilty by a jury of conspiracy to commit first-degree murder, which of these aggravators do you think there's not legal sufficiency for a jury to determine? Because they seem pretty inherent in the charge itself, except for your prior convictions, which, are you saying you don't have the prior convictions within 10 years?
No, I'm not saying that. Which of them don't qualify for the jury to make that determination?
No, you're asking for me to make a determination that there's a legal sufficiency for them to go to the jury.
Correct.
So I'm asking you, if you were found guilty by a jury of the charged offense, which of those aggravators that have been alleged by the state do you think there would not be legal sufficiency for? Because as I look at those aggravators, most of them are inherent in what you're being found guilty of. Again, if the jury found you guilty. For example, the first aggravator, it involved the infliction or threatened infliction of serious physical injury. The allegation is someone shot at the victim. That's the threatened infliction of serious physical injury. So it seems like that allegation, there's sufficient evidence for a jury to decide whether that's an aggravator. The next one, the offense involved the use, threatened use, or possession of a deadly weapon or dangerous instrument during the commission of a crime. Again, if you were found guilty of the charge, as the state has alleged, the jury would find that a gun was used. So that's a separate aggravator, again, that would already be determined by the evidence. The state has alleged an accomplice, your brother. If the jury were to find you guilty as charged, again, my understanding of the state's allegation is your brother attempted to shoot Mr. Boudreaux. You weren't in Arizona. So if the jury found you guilty of this charge, it would mean they found you guilty as an accomplice. If someone shot at the next aggravator, I don't think it's a leap for a jury to presume there's some sort of emotional harm. So I'm struggling with what legal sufficiency you think is lacking for a jury to make those determinations. Again, only if the jury found you guilty of the charge that you're charged with.
I understand, Your Honor, but in 13.5, right, whether capital or non-capital, the state has the burden to establish probable cause, the legal sufficiency of an amended indictment. This is an amendment. This didn't go to the grand jury. Is that correct?
Right.
So now I have the right to ask for a hearing so the probable cause can be found for these aggravators ahead of time.
So you're confusing two things.
Okay.
All right. 13.5B talks about amending the charge or the indictment.
Mhm.
Okay. Your charge is conspiracy to commit first-degree murder. It's not, your charge is not being amended. The grand jury did find probable cause for that charge.
Correct.
An aggravator is not an amendment to the indictment.
It's a whole nother allegation. It's a whole separate allegation.
Difference between an aggravator and changing the charge that you're charged with. If the state were to change the charge that you're charged with, for example, if they changed it from conspiracy to commit first-degree murder to conspiracy to commit second-degree murder, there'd probably need to be a new probable cause.
Correct.
Secondly, as to the allegation that it's a dangerous offense, the grand jury did make that finding because that allegation was included in the indictment that it was a dangerous offense. So there has been probable cause as to the dangerous factor.
Okay, if that is the case, then why isn't that found in the original guilt phase as opposed to having a whole nother aggravation phase after that, as if it's a capital offense? Because there's one statute,
Well, we
there's
used-
one sentence, there's no arguing the sentence. And if it's already a dangerous crime, then there's no reason to have an aggravator phase.
What do you mean there's no arguing and there's one sentence? I don't understand what you're saying.
There's one sentence for
Oh,
the charge. There's only one sentence for this charge. And if it's already classified as a dangerous charge is what you're telling me, right? Because it's conspiracy to commit first-degree murder, that's a dangerous charge. The jury has already found that it's a dangerous charge. Then what is the aggravator phase finding? If it's already a dangerous charge and there's only one sentence.
does the state want to respond why the state wants to proceed with aggravators?
To start with, the jury is not going to make a finding of dangerousness as part of the guilt phase per case law. That's not permitted. So the jury has to make a separate independent finding after they find the defendant guilty. The dangerous finding will include the use of a weapon and or the intentional infliction of or threatened infliction of physical injury. So at the very least, the jury has to make a finding as to dangerousness.
I agree about dangerousness. I guess the question is, why does the state want to prove up aggravators if the jury finds the defendant guilty of the charge as a dangerous offense, given the sentence?
Your Honor, in all honesty, you could ask me this, 10 years ago before Blakely was put out. As case law changes on appeals, I've had to come back before and redo a penalty phase, an aggravation phase, and re-impanel a jury. So I prefer to, since we're already going to have an aggravation phase for the dangerous allegation, to add on the other factors, and therefore I don't have to ever worry about this coming back on appeal later.
All right.
How is it not already found to be dangerous? You just said that if they find me guilty, then it will be dangerous.
I didn't say that. I said if they find you guilty, then they make a determination whether or not it's dangerous. Now, I think what I meant was when a crime involving a weapon is used, whether it's a gun, usually it's sort of a foregone conclusion that if the jury found you guilty of conspiracy to commit first-degree murder by someone shooting at another individual, that they're 99.9% likely to find that it was a dangerous offense. But it's something the jury has to do.
Right, but usually aren't aggravators for sentencing? What other purpose does it serve in this case with this charge, with one statute? You can't give me less time, you can't give me more time, you can't do anything else except for, it's one statute.
I guess the prosecutor's saying she wants to cover her bases in case there's some change in the law and what a jury has to find or not find for purposes of sentencing. And they have the right to proceed with aggravators. All right, you're right in that if you're found guilty of this charge at this level, you get one sentence. But who knows what a court of appeals would do in the future if aggravators or things weren't presented. I don't know that what would be presented at a sentencing phase from your side or from the state's side, but it sounds like the prosecutor's wanting to cover her bases.
So then I'm not entitled to a hearing before trial starts to find probable cause for these aggravators that were not taken to the grand jury initially?
All right,
I'm asking.
I'm trying to explain it to you. The jury did find probable cause that this was a dangerous offense. It's included in your indictment. So they didn't find
these specific aggravators being a dangerous offense, and these specific aggravators.
Can I finish what I said, what I was saying?
Right?
I didn't interrupt you. Can I finish? Okay. The jury did find probable cause on the dangerous allegation. All right. You're not entitled to a probable cause hearing on the other aggravators.
When is conspiracy to commit murder not a dangerous crime?
When someone says they're going to choke someone to death and they don't actually do it, it's not a dangerous crime.
So
No dangerous instrument or deadly weapon was used.
So because some instrument may or may not have been used in this crime, it's considered a dangerous crime?
Right.
And these aggravators that talk about something totally different don't have to be found after that it's found a dangerous crime?
Correct.
And that is supported by case law?
Yes.
So that what? When you go to appeal, you can't say it was a non-dangerous crime?
All right. I don't know what to tell you. All right. There was a case that came out about 15 to 20 years ago now called Blakely that said a jury had to determine aggravating factors. Okay. Before that, a judge determined aggravating factors at sentencing. Now a jury has to determine it. The reason it's not done in the guilt phase is we don't want the jury to confuse the issues. We want the jury to decide first whether someone's guilty or not guilty, whether the state has proved its burden beyond a reasonable doubt. We don't want them to start thinking about other things like aggravators if they have questions about whether or not the person's even guilty. It tends to confuse the jury and confuse the issues for them. So that's why we do the aggravators in a separate hearing. First, you want to make sure the state has proved its burden beyond a reasonable doubt as to your charge.
But these specific aggravators that they allege, right, the ones that you just went over, you're saying that now after you're found guilty of a dangerous crime, that they're going to go back in, and what is the purpose of that? How does it change anything after that?
I don't know how else to explain it to you. So do you have other issues that you want to bring up today?
Yes, but I would like to finish this first. So are you denying my motion to have a hearing on this?
I'm denying your motion to have a probable cause hearing as to the state's alleged aggravators.
Okay, so you're denying my motion to have a 13.5 hearing on these alleged aggravators
Correct, because
before trial starts.
you're not entitled to one.
Okay,
13.5 says that you're entitled to a probable cause hearing if they amend or change the indictment.
this is not an amendment of the indictment?
It's not. There's a difference
It's an
between,
extension of the indictment. It's not in the indictment.
it's a difference, okay, between an aggravator and changing the charge that you're charged with. Changing the charge that you're charged with is an amendment to the indictment. For example, if you were just charged with conspiracy to commit first-degree murder, all right, but the state didn't allege with the grand jury that it was a dangerous offense, you'd be entitled to a probable cause hearing as to that dangerous allegation because it's changing the charge and it's changing the sentence that you would be getting. These
But that's
aggravators,
exactly my point. How after the fact, these aggravators, if they're found, what do they do to change the charge or change the sentence or change anything?
probably nothing in reality. You just said it. They don't change the charge. So you're not entitled to a probable cause hearing.
Okay, then I don't want to have an aggravation phase either.
Well, you can
How
not.
are you entitled to that? And I'm not entitled to a hearing on probable cause, but you're entitled to have an aggravation phase.
Well, if you don't want to attend, you don't have to attend. What else?
All right. Something dealing with trial is that I've asked several times for headsets for my advisory council. I know that's been an issue that you said we can only have 5 headsets. Is there some way we can do that? Because it's very difficult for them to advise me on things when they kind of don't know what's going on.
If you need a break to consult with your advisory council, we can do that. I can only give so many headsets.
You said you were going to check into that. Is that something that
They
you did
said
check
they-
into and
they
there's no
can't
more
do-
available headsets?
They can't do more than 5 on that particular system or network that they have. I need my court reporter to have one so we can do the sidebars. The state's only getting 1. I get 1, so that leaves 2 for you. Whoever you want to have besides yourself, you can choose one of your advisory council or your paralegal.
But you're forcing me to choose between the people that are helping me?
Sure.
Okay.
Technically, I don't know I even have to do that. You represent yourself. You're considered your own attorney. You don't even have the right, the right to consult. I shouldn't say that. You have the right to consult with them, but it's not a necessary thing. Because you are acting as your own attorney, you're expected to proceed as your own attorney. They don't have an affirmative duty to even give you advice under the case law for being an advisory council. The fact that they do is probably helpful to you, okay? But you chose to represent yourself. It means you are supposed to act as your own lawyer.
You appointed them and assigned them to me. I did not ask for them.
Okay, yeah, I did, in case you decided not to represent yourself so they could step in at trial.
Okay, well then is an alternative that we could do sidebars at the bench so that they could be involved during
I
that
think it
time.
depends on the complexity of the question. If it's a simple jury question that, like, for example, can we have a copy of the police report? The answer to that is always no. So I think I'll have to take it on a question by question and issue by issue basis. So if it's an issue where we need everyone at the bench, yes, we can do that. But if it's a simple, quick response that we can do with the headsets, we'll do that.
Okay. I have one more issue.
Go ahead.
Okay. Seeing as how things went in the last trial, my question is, what does the state intend to bring in from Idaho so that I can prepare my questions without being accused by you of opening the door? How can we avoid that when almost every witness has testified in my Idaho trial? And I don't want to be responsible for doing that. So how are we going to handle that?
Well, I will tell the prosecutor to make sure a caution is given to each witness that no matter what the question is, that witness should not think it's a question that would require an answer about prior testimony or prior proceedings. State agrees, right?
Yes, Your Honor.
I guess they can be further advised that if they think you or the state is asking a question that calls for that sort of answer about prior testimony or prior proceeding, that maybe we should take a break.
Okay,
All right. Anything else?
that was it.
All right. We'll see everyone.
She said, if all parties can resolve that also means that we can bring in the survivors whatever time tomorrow since they have doctors.
Okay, well, we are
Okay,
definitely
so
heading to
I'm
trial.
being informed that the jury commissioner said if the parties stipulate to not bringing in any jurors tomorrow, we can do that. Remember last time, though, we screened whatever number we had. A few of those people didn't show up, even though they were informed they needed to show up. So we have 66. I think because it's a shorter trial, we don't necessarily need 4 alternates, but maybe we should just in case. I don't know.
Judge, I would still want 4, given that we lost
We
2 in
lost-
the first 2 days.
We did.
I don't want to waive any appeal issue that
Okay, well, the hearing did cut out on the rest, but it is around the jury selection issues, and that definitely you can find the details on Nat Eaton's thread on X, which I'm going to put below through a thread reader app that will update, as it goes, because it was still going on as I was preparing this short video of the proceedings. Now, as far as I know, they are going to be continuing with jury selection tomorrow. Other issues that come up on motion will be addressed. I just want to make this personal note. I would say that Lori Daybell is very lucky to have this judge. This judge has been berated by Lori, has been accused of being biased and unfair. And we just witnessed a hearing where that man, with patience and grace, put everything aside to do his job to the best of his ability to make sure she has the information, and not only just the information, but a clear understanding. He's trying to direct her into doing the best that she can for herself in regards to being an attorney, all the while being challenged, berated, and demeaned by the defendant, who is her pro se attorney. He does need to educate her when she is crossing the line and expecting too much, because that's damaging for her and a time waste for her. And he is trying to pull her back to get to the facts of the case. Like, you have a misunderstanding here. And he took time to give her that information. I think he's an excellent judge. And I think at this point, she should be considering herself lucky that he is the patient and just believes in the justice system the way that he does and approaches his duties with such professionalism. At the same time, pushing her back to keep her within the parameters of what her rights actually are. Because she is, in my humble belief, acting quite entitled and has a great misunderstanding of some of the basics of what things should be. I don't know if it's the questions that she asks her counsel, but I saw her referring to her investigator, several times in the last trial instead of the counsel. So, I don't know if it's the information that she's getting or not asking the right questions, or her interpretation. Based on what we've seen on her in other trials, I do believe it could be mostly her interpretation of what she hears. But on that, let's say goodnight. We are moving forward with trial. June 2nd is the start date for testimony. It does look like the jury will be seated well before that if things go like they did last time. They will still be looking for 4 alternatives on top of the regular jury, based on what happened. I do believe I said that this hearing was May 28th in the beginning. And if I did, I misspoke. It's definitely May 29th today, Thursday. And my apologies. It's been a long day. But let's get this out to you guys. And we'll be updating again on Tuesday, True Crime and Legal Update at 7 o'clock on Clairview. This, amongst other cases, will be discussed on that night. Day-to-day coverage right now is on the Karen Reed trial. Hopefully I will see you there. Have a great night.